Thank you everyone for joining us for this timely and important topic. I'd first like to say good morning, good afternoon, good evening, wherever you are in the world. We're very pleased that you're able to be with us today. We've got some great experts that are going to come through some really complex issues, and we'll leave some time for question and answer at the end. My name is Everett Eisenstadt. I'm a public policy partner in the Squire Patton Boggs, Washington, D.C. office. It's really my honor to serve as today's moderator on this timely webinar on global deforestation regulations, how initiatives in the European Union and the United States will reshape global supply chains. Just to put this briefly in context, the EU deforestation regulation has already entered into force. It will prohibit the placing of relevant commodities and products in the EU market or exported out of the EU if they are not deforestation free and complying with the legislation of the country of production. Various actors will be affected by these in many different ways, and we'll have an opportunity to dive into that today. Similarly, in the United States, a bipartisan group of senators have introduced the Forest Act, which would require importers of certain products identified to be deemed at high risk for contributing to illegal deforestation to certify that they have mitigated the risk, among other requirements. The impacts of both of these this bill in the United States and this regulation in the European Union are going to be felt around the world, particularly for products in the wood, beef, palm oil, soy, coffee, and rubber sectors. So to help us understand the status and implication of these initiatives, we've gathered a number of experts. Each presenter will speak for about 8 minutes, leaving us time to address your questions at the end. So with that, let me turn it over to Christina, who is going to kick us off, and we're looking forward to your remarks. Thank you, Christina.
Thank you, Everett. Hello, everyone. My name is Christina Economides. Welcome to our webinar for today. We will be starting our presentation with an overview of the EU Deforestation Regulation. That's an overarching EU law that has already been adopted and will be setting the scene for the broader webinar. So back in November 2021, the European Commission published this novel regulation, the Deforestation Regulation, that is also known as EUDR for short, which has been adopted and now has been enforced since June 2023. But however, there's still some time before companies can comply with the rules, and also regulators implement the rules, considering that the entry into effect of the rules, the application essentially, starts from the 30th of December 2024. From that moment, an array of new obligations will be commencing, and that will change the way that supply chains of the products in scope will be done in the future. To begin with, the EUDR serves as a fundamental element of the EU's Green Deal, which is an integral component of the broader comprehensive strategy that the EU has put forward, and the EUDR is part of the forest protection element of the strategy. And the overarching goal and objective of these rules is to mitigate the impact of deforestation and forest degradation. Specifically, this impacts the way that the forest degradation will be impacted, but also how the biodiversity will be preserved, as well as the aim to reduce greenhouse gas emissions. The regulation establishes very strict due diligence requirements for companies that will be placing certain raw materials and products made from them on the European market or that exports them. The scope includes very specific commodities which have been already outlined, and that includes wood, beef, palm oil, soy, coffee, cocoa butter, rubber, but also derivatives of these products. So there's a lot of other elements and other products that can be that are part of those elements and will be essentially put forward. What companies must be mindful of is the fact that the list of products and raw materials will be regularly updated and reviewed to account for the changing deforestation patterns and also the market developments. If we can move to the next slide, please. So more broadly, the regulation, as we said, sets these mandatory due diligence rules for companies that want to place these commodities on the EU market. with the aim to ensure that only deforestation-free and legal products are can be allowed to enter the EU market. As such, the regulation will have important and significant international implications, especially on the trade of forest-related products. There is therefore a prohibition of the regulation to ensure that only relevant goods or commodities on the EU market can be placed unless they are deforestation-free, are produced in line with the relevant legislation or of country of production, and they're covered by a due diligence statement. There are, of course, some exceptions that are introduced with respect to SME operators and traders. And of course, the EUDR sets up this distinction between operators and traders, which will essentially help to define how a company will be required to comply with the EUDR. So the operators entail entities that in the course of their commercial activities will be placing relevant commodities and products on the EU market, or who are exporting them from the EU market. And here, when we talk about placing on the market, we're talking about first making available on the EU market, and also the making available on the EU market that refers to the supply. So that covers any type of supply. And then the second element are the traders that introduce entail the natural and legal persons in the supply chains that are other than the operators, who within their commercial activities will be making these commodities in scope and products available in the EU market. Of course, as we said, there's a number of compliance obligations that are embedded within the EUDR, and we'll go into a deeper dive on this issue, because there's also some legality requirements that will need to be considered by companies. And so with that, maybe I would like to hand over to my colleague Thomas, and maybe we can move on to the next slide.
Thank you very much, Christina. I'm Thomas Delille, partner at Squire Patton Boggs. And Christina, you're certainly right that we are already entering a compliance time for the EUDR. Thank you very much for detailing or providing us with the overview of that legislation. It sets up some very burdensome obligations on companies. Applicability by the end of 2024. It means we are entering a moment where we need to think about compliance. EU authorities are also doing so. We got some Q&A published by the European Commission back in December, which provides some further granularity on the obligations set up by the EUDR. If we have to summarize the situation, the EUDR provides that relevant commodities and products shall not be placed on the EU market, shall not be made available on the EU market or exported, unless they comply with a deforestation-free requirement and what we would call a broader legality requirement. Coming back to the scope of application, we talk about a list of commodities that Christina detailed, but also products containing those commodities, if I may summarize that way. An interesting feature is that those so-called relevant products are listed in Annex 1 of the regulation, and we got confirmation from the Commission that only the product listed in that Annex 1 would be the one covered by the EUDR so far. So really distinguishing obligations within the supply chain between those furnishing those relevant products and those potentially integrating those relevant products in their own products before placing them on the market. Now coming to the twofold obligations. First, a deforestation-free requirement, meaning that the relevant products shall have been fed with or have been made using relevant commodities that were produced in land that has not been subject to deforestation, setting a cutoff date on 31 December 2020, with some sort of retroactivity in that respect. And in the specific situation of wood, the wood need to have been harvested without inducing forest degradation after that same cutoff date of December 2020. Beyond that deforestation-free requirement, there is a broader legality requirement, meaning that those products need to have been produced in accordance with relevant legislation of the country of production, including countries outside the EU, so introducing an obligation on operators placing products on the EU market to comply with legislations from third countries. In that respect, there is a very broad understanding of what we mean in terms of complying with legislation of the country of production. It's not only about land use, environmental or biodiversity protection related legislations, but more broadly, also legislations related to human and labor rights, rights of indigenous people, good governance, etc., etc. This takes part to a broader trend we see in the EU of EU authorities placing more and more obligations and burden on companies placing products on the EU market to comply with what would be called ESG-related obligations. And the deforestation, the EUDR is a good example of a sectorial regulation where EU authorities put some ESG-related obligations on companies. The driver for compliance is very clear. There will be no placing on the market in cases of non-compliance, but also in cases of a non-negligible risk of non-compliance. May we move to the next slide, please? So setting or putting due diligence obligations on companies, what does that mean? Due diligence will need to be conducted prior to placing relevant commodities or relevant products on the EU market. For that, companies will first need to set up a so-called due diligence system, where they will have an obligation to establish, but also to keep up to date, a system to gather information, to conduct a risk assessment, but also potentially to identify and apply some risk mitigation measures in any situation there is a non-negligible risk that is identified. Beyond the setting up of that due diligence system, there is also some correlated reporting obligations. First, companies will need to submit a due diligence statement into an EU information system, and Christina will come back on that will need to be set up by the EU Commission in a harmonized manner. It goes pretty far in terms of the information that needs to be submitted. A very good example of that is the need to provide geolocation data of the land of production, as well as the date of production of all relevant products. And this all needs to be verifiable by authorities in case of checks. Beyond that, companies will need to make authorities aware in case they get new information which could indicate a risk of non-compliance. And again, beyond that, they will also need to publish a report on their due diligence system containing some pretty detailed information, which means again that the EUDR is taking part of a broader ESG trend related to disclosure of information from companies placing products on the EU market. Next slide, please. We summarize here somehow the obligations related to due diligence. Coming back to information requirements that we covered just in the previous slide. The risk assessment, where there is a need for companies to verify and analyze the information they collect in order to evaluate and assess risk. To that end, the EUDR provides for some risk assessment criteria that, again, the Commission will need to further detail in some implementing legislation, but still, we already have some concepts or principles for that risk assessment, including the fact it should be based on country risk categorization, meaning that depending on the region of origin of the product, there will be a different level of risk that need to be associated with some high risk zones within some given countries. Upon that risk assessment, an obligation to adopt some adequate risk mitigation policies unless there is no or only a negligible risk of non-compliance. The regulation also provides some details on the risk mitigation measures that needs to be adopted by the operators concerned. May we move to the next slide, please? The EUDR is certainly putting a huge burden on companies that will fall in its scope. But not only on companies, also on the member states of the EU that will need to implement and to enforce the EUDR. And in that respect, the pressure is also high on those member states to deliver when it comes to enforcement. They will have an obligation to perform checks on compliance of operators and traders, as well as on relevant products. What is a very important feature in that regulation compared to others is that the EU legislator is setting up some detailed objectives in terms of percentage of products that needs to be checked depending on the country of origin. So it will all take part of a risk-based approach, but we are talking about member states being obliged to verify beyond 9% of operators from high-risk countries and 9% of the quantity of products coming from those countries, which is certainly not negligible and will be also another driver for compliance on that regulation. The EUDR also provides a variety of tools, of enforcement tools to authorities. In case authorities have indications of potential non-compliance, they will have the opportunity to seize or suspend the placing on the market or the export of product. Beyond that, in case of a potential high risk of non-compliance, in such case, authorities may adopt interim measures, since they are under the obligation to take immediate interim measures and require customs to potentially suspend the release or free circulation of the goods. And in any situation of established non-compliance, competent authorities shall without delay require operators and traders to take appropriate and proportionate corrective actions, including either the rectification of non-compliance, or potentially the prevention from placing on the market, or the withdrawal or recall of the product placed on the EU market. This is certainly far-reaching, very new, and clearly a sign that the EUDR will have concrete consequences in shaping supply chain in the EU and more globally. There are some penalties that will be associated to breaches of the EUDR. They will be specified in national law, but can include fines, at least 5% of the total EU turnover. Beyond that, potential confiscation of related products and revenues, the possibility for operators to be excluded from public procurement processes in case of repeated breaches, for example. There could also be temporary bans on placing or making available of relevant products on the EU market, and so on and so on. This clearly shows that the EU legislator has a willingness for the EUDR to find some concrete consequences and concrete compliance within the EU. And with that, coming back to the more legislative process, I give the floor back to Christina to detail some upcoming developments in that regard.
Thank you, Thomas. So as Thomas already outlined, there's all of these compliance requirements that would need to be undertaken ahead of the application date, which is the end of 2024. In the meantime, and at the moment, there's still some additional elements that are being negotiated at the EU level, which relate to secondary legislation, and these are already outlined in this slide. The European Commission is already in preparation phase with respect to the compliance. It has issued twice frequently asked questions that detail their interpretation of the EUDR. At the moment, the member states are also in this preparation phase where they are expected to announce and appoint their competent authorities that will be responsible for the enforcement aspects. So that they will have a very critical role in the discussion with the industry and also with respect to the enforcement obligations of the EUDR. And at the moment, the Commission is also having a lot of discussions with the industry through For example, the multi-stakeholder platform that on protecting the forest and restoring the world's forest that is still ongoing, and there's a lot of information and working groups that are being held with industry players and even smaller companies that are and NGOs that are involved that are also assisting the European Commission with respect to how the EUDR will be implemented. There's already a couple of elements that have been published already. One has been the EU's information system, which is a pilot phase of the actual EU's information system that will be part of the EUDR compliance. That was launched in December last year, so 2023, where there's a lot of testing phase that happens. Of course, the information system is one of these tools that will be facilitating the submission and process of the due diligence statements that are embedded in the EUDR for the operators and the traders, and that will also have the alignment with the competent authorities and the customs authorities to ensure that there's going to be a smooth transition when the actual implementation happens at the end of the year. Similarly, there is the EU Forest Observatory, which is an online tool that includes reference maps that can be helpful for both traders and operators. It includes a number of metrics. It's not a legally mandatory tool, but it's still one that can be helpful for the EUDR compliance. And then global partnerships and discussions that the EU is leading, namely through the Team Europe initiatives and the Zero Deforestation Hub that the Commission is managing with third country operators. In any event, just to conclude on the EU side, there's still a lot that is being developed, even though there is an agreement on the actual law and we have the law in paper. There's still a lot of details that are being ironed out at the moment. So until the end of the year there's going to be still many things to follow that will impact the way that the EUDR is going to be implemented, and of course that will heavily influence the broader supply chain ecosystem in the way that companies will be required to operate going forward. And of course, the EU just covers one part of the spectrum, and there's a lot of things that happen on a global scale, and the US is now taking some additional steps into forest law, and we'll also be covering that on the second part of the presentation with our US colleagues, and perhaps with that I can hand over to Mila to cover the US side of the spectrum. Thank you.
Thank you, Christina and Tomas and Everett, and thanks everybody for joining us. So now I'm going to give you a short preview of proposed legislation in the United States that would similarly seek to address the risk of deforestation through import into a market. The Forest Act of 2023 was introduced by Senators Schatz and Braun, and then Representatives Blumenauer and Fitzpatrick in the House. It is really being driven by Senator Schatz's office, and this is not the first time that it's been filed. This is the second time at least, but it has been developed over years of consultations with industry. It is a proposed bill. It has not advanced at all in the Congress, but in its current form, it reflects significant inputs, and the framework addresses a lot of concerns I think that industry have raised over the years. At the end of my section, I will pass it to Everett to tell us whether and when we think the Forest Act might advance, just so to give you sort of a sense of the challenges that are facing trade, just moving any trade bills in the U.S. Congress right now. And as many of you may know, import bans like this are not new in the United States. The Trade Act of 1930 included in its earliest iterations a prohibition on the importation of goods made with forced labor. That legislation has garnered significant attention in the United States as it's been leveraged to address importations from China and portions of China where there is alleged forced labor practices. The Forest Act goes about it a little bit differently, and similarly to sort of other frameworks like the Lacey Act and things like that. There had been some debate among the trade industry about structuring the Forest Act around Section 307's forced labor import ban, adopting similar regulations, creating similar rebuttable presumptions. That is not evident in the final text, at least as it currently exists. And I think a lot of the provisions that I'm going to describe to you briefly now address what I think were some of the weaknesses in how Section 307 has been administered, and particularly on the side of business and making it workable. And then I think for all of you and your companies, ultimately, it's about looking at the framework and determining whether that framework is workable. And if it is not, now is really the time to be engaging with members of Congress and other stakeholders to seek ways to make it workable in the event that it should advance. So at its basic level, the Forest Act would prohibit the importation of any product made wholly or in part of a covered commodity produced on land that undergoes illegal deforestation. In doing so, the prohibition actually goes into effect immediately upon enactment, but within a year after enactment, importers and sort of that lag, I think, is a little bit of a question, at least something for continued discussion. Starting 1 year after enactment, importers would not be able to import a covered commodity unless they electronically file an entry declaration for most products. So maybe from countries, covered commodities from countries that aren't necessarily identified to be at risk. It would just be stating that they've exercised reasonable care. And for products from countries that are subject to an action plan, those countries that have been determined to be at higher risk and sort of the United States is seeking a higher domestic practices and structures to protect against deforestation, the declaration has to have a higher showing, including information on the supply chain and steps that have been taken to assess and mitigate different risks. And what is, I think, really important, and I addresses some of the questions that have come up under previous frameworks, is that the Secretary of Homeland Security is directed to issue guidance on what constitutes reasonable care and what constitutes sufficient information under those two requirements. And this question of reasonable care has been, a major one for years for a lot of the trade industry when it comes to Section 307. And some might ask why the Secretary of Homeland Security, given that Customs and Border Protection is the one that would be implementing. And it obviously CBP falls under DHS, the Department of Homeland Security, but also Homeland Security is the agency that is managing some of the forced labor enforcement. So I think there is sort of a growing, my view is that there could be some sort of a growing expertise at DHS and their trade officials there. Another key aspect that I think also comes from the industry is establishing a trusted trader program, establishing a streamlined framework for importers that have shown, basic levels of due diligence, track record of compliance. I think this is something the industry really likes to see, particularly many of you. It's something you would probably want to explore once it's established. Now, the Forest Act includes a preliminary list of commodities and covered products. The U.S. list does not include wood, but we actually, we do have the Lacey Act for a number of those products, and it does not include coffee. But otherwise, the preliminary list does include palm oil, soybeans, cocoa, cattle, and rubber. And then it does list out specific HTS codes, harmonized tariff schedule codes for covered products. But this is the basic list that's established by statute. The Office of the U.S. Trade Representative is directed to review the list annually, and there is a public process there would be a public process for expanding the list and exploring additions. And then for those countries sort of that would be subject to the more onerous importers would be subject to the higher level of entry declaration. Those countries the United States would develop action plans for those countries without adequate and effective protection against deforestation, and establish sort of a rubric for how to address those risks and establish some funds to support countries that are seeking to improve their policies. There are there are enforcement mechanisms. There are opportunities for the public to allege violations of the restrictions. This is, again, a mechanism that exists for Section 307. There have been a number of concerns from importers on Section 307 that there is not an opportunity for them to provide information regarding an accusation before an enforcement action would take. And the Forest Act would actually direct an opportunity to notify the importer and offer them the opportunity to provide additional information in rebutting such an allegation before an enforcement action. So I think that's an important development as well, and just sort of an evidence of how there's been a little bit more thought put into the statute. There's been a little bit more structure put around how this kind of an import ban would function. I mean, there would still be a number of provisions and structures that would be developed via regulation, but those are just a few key provisions, definitely not a full summary. I just want to note a couple other items that are that would be of note. I think overall, this is structured as a sort of carrot and stick approach for different countries, an incentive for them to help, for those that are taking it seriously, to develop a plan, to implement the plan, and to make it easier for companies to develop to show the requisite levels of information to have the easier sort of entry declarations. I think as well the fact that it was not ultimately a direct reference back to Section 307 in that framework, and where it's developed there have been so many concerns with enforcement and enforceability over time, that it suggests significant understanding, I think, from the Congress on the struggles that the industry have faced. So overall, I think the road to enactment is not an easy one in the United States right now, not necessarily just because of the challenges to industry, not necessarily because of the inputs that many of you may already be making to your lawmakers and to the administration on the challenges of making the requisite showings and the potential impacts on the U.S. economy. I do think, there could be a whole other seminar talking in the United States about how there are increasing pushes from both sides of the aisle in the U.S. Congress to set up, trade programs that don't necessarily promote just free trade, but make sure that trade is fair and that address different concerns. I think Republicans and Democrats may go at those concerns differently. For some, Democrats, it can be, the sorts of ESG concerns that, Karen will speak about momentarily. But for a lot of Republicans now, it's about the fairness and competition for U.S. goods. And I, not to put him on the spot, but I think Everett is, given his experience on the Hill and in the administration and at USTR, can speak better to this, that the dynamic for a trade bill right now is extremely challenging. In an election year, it's always challenging. In an election year like this one, where trade is going to be such a central part of the debate and a politically contentious issue, it's an even harder one. But Everett, I'll turn it to you first in case you'd like to say anything, and then I'm happy to defer to Karen.
Yeah, I wasn't expecting to actually be a participant, but I'm happy to add a couple of points. I think you're exactly right, Mila, that this year passage of a bill this complex would be a challenge. It's difficult for the Congress to even get the budget process, the appropriations process done right now, and time is moving fast, even though it's only January. I think it'd be very difficult. That being said, it is a mistake to ignore these bills, and they represent trends that don't go away. As you noted, Mila, this has been introduced twice. It's going to come back. So if you want to have impact, you got to stay engaged. Even if it's not going to happen this year, it's not going to go away. And a lot of the concepts that are being articulated will find themselves in other pieces of legislation or in administrative actions as well. So it's important to watch these trends and threads. But with that, I'll turn it over to Karen, who will talk a bit more about the broader ESG dynamics. Thank you, Mila. Karen?
No, thanks, everyone. Hello, my name is Karen Street, and I'm a principal in the Public Policy Practice Group of Squire Patton Boggs, Washington, D.C. office. Now that my esteemed colleagues have provided a pretty thorough review of deforestation regulations enacted in the EU and proposed in the US, I'd like to pull the lens back a bit to discuss their intersection with a much broader agenda that was briefly touched on by Tomas, ESG, which stands for Environmental, Social, and Governance. Increasingly, ESG represents a framework through which both public and private entities evaluate their impact on sustainability ethical practices, and governance structures. ESG principles have a significant impact on deforestation policies by influencing how companies, investors, and governments approach and address issues related to environmental sustainability, social responsibility, and effective governance. So let's briefly discuss how each of these principles align with deforestation regulations. So first, environmental impact implicates both forest conservation as well as carbon emissions and climate change. The E in ESG obviously places a strong emphasis on environmental sustainability, and companies are increasingly expected to adopt policies that prioritize forest conservation and sustainable land use. Additionally, deforestation contributes to increased carbon emissions and climate change. So under ESG principles, companies and governments are encouraged to mitigate these environmental risks by implementing policies that reduce deforestation and promote reforestation efforts. Now, secondly, social impact implicates community engagement, and in this case, indigenous rights, as well as labor practices. Deforestation often affects local communities and indigenous populations, and ESG principles call on companies to consider and engage with these communities, respecting their rights and ensuring that the social impacts of deforestation are addressed responsibly. ESG also emphasizes fair and ethical labor practices. So under an ESG framework, companies involved in deforestation sensitive industries are urged to ensure that their labor practices align with social responsibility standards, including the well-being of workers and local communities affected by deforestation. Lastly, governance implicates both transparency as well as supply chain governance. ESG calls for transparency and accountability. So under an ESG framework, companies are expected to disclose information on their deforestation-related activities, enabling stakeholders to assess their environmental impact and commitment to sustainable practices. ESG also encourages companies to assess and manage risks within their supply chains. This requires supply chain diversification, reducing dependence on regions prone to deforestation-related risks, and building resilience against potential disruptions. So in terms of a comparative analysis, it's clear that the EU and the US have different approaches to deforestation policy, and that's really no surprise as they have very different approaches to ESG principles more broadly. Turning our attention to the European Union, we find a beacon of global leadership in ESG policies. The European Green Deal is a comprehensive initiative that outlines the EU's commitment to becoming the world's first climate neutral continent by 2050. Supporting this, the Corporate Sustainability Reporting Directive and the Sustainable Financial Disclosure Regulation mandate transparent reporting on environmental and social performance. The EU taxonomy for sustainable activity further refines what constitutes sustainable economic activity, fostering some clarity and consistency on the issue. The European Pillar of Social Rights underscores the commitment to fair working conditions and social inclusion. And finally, the EU's Sustainable Financial Action Plan is driving the integration of sustainability into financial decision-making. So clearly, the EU's holistic approach sets a benchmark for global ESG leadership. Now, in contrast, the United States has more of a patchwork approach to ESG. The Biden administration has prioritized climate action and sustainability through several executive orders and various federal agency actions, particularly at the Securities and Exchange Commission. For example, the SEC's proposed climate risk disclosure rule is a significant development aimed at enhancing disclosure requirements related to climate risks. Additionally, the SEC's amendments to Regulation SK reflect a broader effort to include human capital management and social impact in corporate disclosures. Also, the SEC's proxy voting advice guidelines add a layer of transparency to proxy advisory firms, influencing institutional investors' voting decisions on issues like ESG. Additionally, the Federal Reserve's Financial Stability Report is increasingly acknowledging climate-related financial risks, and the Department of Labor's ERISA guidelines signal a recognition of ESG factors as economically relevant for retirement plans. Meanwhile, California, the largest subnational economy in the world, has enacted two significant climate-related disclosure bills: the Climate Corporate Data Accountability Act, which will require certain companies to disclose their direct, indirect, and value chain greenhouse gas emissions, as well as the Climate-Related Financial Risk Act, which will require certain companies to disclose climate-related financial risk. Lastly, I'd point out something that we all know: every action has an equal and opposite reaction. And as ESG principles gain prominence, so has the phenomenon known as greenlash. This refers to a backlash or negative reaction against environmental initiatives or policies. It's important to note that all of the US federal administrative actions that I mentioned are subject to litigation, and some of them have already been litigated. They're subject to congressional review, reversal under a different administration in the future. Not to mention the Supreme Court's impending decision on the 40-year-old doctrine of Chevron deference, which requires courts to defer to agencies' reasonable interpretation of laws passed by Congress. The reality is, ESG, like DEI, diversity, equity, and inclusion, has become a political flashpoint. And there are strong forces on either side of these issues. And what began as an anti-woke agenda for conservatives in the US has recently crossed the pond to the UK, though it's yet to be determined if it will truly take hold there and beyond in the EU. So it's very clear that the broader implications of ESG principles on deforestation regulations are monumental, but they are also ever evolving. And that places companies in the position of navigating these very murky waters, one way or another, which makes advice and advocacy all the more important. So with that, I'll yield back my time.
Great. Thank you, Karen. And as a reminder, we welcome questions. We have a number in the queue. We've got about 15 minutes for questions and answers. I'll just start with before we dive into those, I'll just start with an observation that I think many of our speakers made, is that the inclusion of issues like deforestation, labor rights, forced labor, environmental issues are becoming increasingly interlinked with supply chains and commerce. And I don't think that trend is going to dissipate. It used to be that you had to have a particular linkage to trade to keep an import out, and now it's much broader than that. It's impacting markets around the world, how people are doing business, and it's moving at a very, very rapid clip. So as you noted, Karen, this creates some difficulties for many corporations and even small producers to, one, keep up, and two, to comply. And it really requires kind of a holistic approach of internal governance to be sure you understand, the regulations and are able to have the compliance systems and mitigate the risk internally. So it's definitely a new era. It's one that's going to be around for quite some time. So let's turn to some of the questions. We have one regarding the European Union in particular. It says, it's a very specific question. It says, does a retailer who has not imported a product into the EU market count as a trader, or does trader refer to organizations further down the supply chain? And I don't know, Christina or Thomas, if you want to take that.
I think I can take that one, Everett. Thank you. Thank you for that question. You're related to the scope of application of the EUDR. In short, this retailer may count as a trader. If we look at the EUDR, what the EUDR does is to distinguish between operators and traders. So operators are those responsible for the first making available of the commodity or the relevant product on the market, whereas a trader is anyone making available on the market. Therefore, not only the first making available. The import as such is not of importance. What is important here is first to consider if we are talking about a relevant product, so a product listed in Annex 1, and then in such case, yes, potentially that retailer may qualify as a trader with all associated obligations within the EUDR.
It's very far-reaching into the entire supply chain. It's very interesting. So when we look at the three major markets in the world today, China, the United States, European Union, consumer markets, we really have different systems set up. So concerns are being raised about, particularly, sustenance farmers who may be cocoa farmers or coffee farmers, who don't really have the capacity to comply with, say, geolocation data, or may not even have access to, good digital services to understand the regulations. Is there a danger? This is really kind of a twofold question, because I want to approach it in two ways. Is there a danger that those semi-marginalized individuals might become further marginalized from the global supply chain, and move their products into markets that don't have these commitments or obligations, or simply not be able to comply and not be able to sell their product? And that would be my first question. Then I want to do a follow-up, and I'll open that up to the panel.
Maybe I can take that one. Just from the EU side, there's definitely a lot of leeway with respect to smaller companies. So the regulators and the competent authorities will definitely have a more of a lenient approach towards the smaller companies. The European Commission, as I said during my presentation, is also planning to issue a number of tools that will be helping companies to comply, and especially those smaller producers that may have difficulty or not the resources internally to comply with the strenuous compliance obligations. And equally with respect to, as you say, the geolocation data and some of the information that is required to ensure that the data provided in these in the broader compliance requirements, or the due diligence statements, etc. So essentially the data that needs to be verifiable that they are deforestation free. There's also an EU tool that is currently live. It's called the EU Forest Observatory, and that includes a number of reference maps on a global scale, and can include information that will be useful for smaller operators that can help with their compliance regime. But equally, within even the EUDR, there's more leeway and ability for the smaller companies to comply at the later stage, and with more comprehension with respect to their resources.
And maybe if I can complement on what Christina just said, there is clearly the objective, at least of the EUDR, to improve transparency within the supply chain. So there will be pressure to improve geolocation, for example. But we also need to keep in mind that the obligations are placed on operators placing commodities or relevant products on the EU market. So not much the local producer itself, although ultimately, of course, the entity placing the product on the EU market may be putting some pressure on the local producers to be able to locate the goods. So there will certainly be a dialogue within the supply chain, but ultimately it may also be the entities that will ultimately be subject to the obligations that will put all of that into place in order for some more local entities to comply. But yes, if ultimately there is no willingness to improve transparency within the supply chain, some actors may lose opportunities to stay within the main global supply chains.
Yeah, it's very interesting. Just kind of looking at this from the U.S. perspective and the impact on the countries. that may be deemed high risk or not having adequate laws in place. Mila had mentioned something called an action plan, which had been derived out of really entry into force requirements for free trade agreements that are now being used more broadly to help countries comply with other types of trade initiatives. The fact this is in the Forest Act is pretty interesting. And I wonder if there's any movement in the EU as well to provide capacity building or other elements for countries that may be subject to this and not be able to bring their laws up to compliance.
I think that's a very good question. If I draw an analogy with another biodiversity-related field, so access to genetic resources and benefit sharing, we saw a similar situation of the EU trying to put the onus on EU operators to comply with law in third countries, with a huge variety of those legislations in terms of rules of law, etc., etc. And in the meantime, we also saw some developments of some NGOs helping those countries to set up more well-drafted legislations in order, in return, for companies to be able to comply with those. So I guess we may see the same kind of developments when it comes to the EUDR. Now, I see in the Q&A list also a related question on the role of certification bodies. They may well also be one of those intermediaries that ultimately will be able to shape the supply chain in an EUDR compliant manner, the same way they have done so outside the legislation, except for wood, because the timber regulation was already there and they already played their role within that regulatory framework. So we may see the same kind of developments for other commodities such as palm oil, where certification bodies also exist, and so on and so on.
Yeah, it's a really excellent point. And I think Mila and Karen talked about in the U.S. the ability of third parties to have input into new products being put on, and that's somewhat of a new dynamic in the United States as well, where you have NGOs and others who have a seat at the table and have the ability to impact what goes into the regulatory and how they're implemented. And so your points are really well made, Thomas. And in that regard, yes.
I just wanted to add, I don't want us to overlook the impact that individual companies can also have in this space, certainly on a more of a voluntary basis. I know, for instance, that JBS, who has taken great strides on this issue and puts a lot of effort into outreach directly with local farmers and ranchers in Brazil to try to provide technical assistance. It's really important, again, with that social impact, to be engaging directly with communities that are impacted by deforestation, oftentimes indigenous communities, to not only help provide information, but a lot of the technical assistance that they need to comply.
That's a great point, Karen. Thank you for raising that. And just, Mila, do you want to comment on that? And I'd like to get a little more specific on the role of certification bodies.
I was gonna comment on both. I wanted to go back to the first question because I think your question, Everett, raised this whole sort of existential issue facing sort of U.S. trade policy making, in that we used to do things by consensus. We used to seek high consensus at sort of these broad-based bodies like the WTO, like WASENAR, like all these things. And we used to negotiate these bilateral and multilateral free trade agreements where we would seek these, gold standard agreements. And when we're not doing those things anymore because of the political complications in the United States, these kinds of systems, and sort of the largest markets like the EU, those are trying to set the rules of the road for everybody else. But your question about whether it'll set up sort of, supply chains going to other markets is a really interesting one, because it leads me to think, we're talking about AGOA reauthorization. How will these kinds of principles fall into, restructuring AGOA requirements? Sort of the dynamic has changed, and how we get the world supply chains to follow our lead is changing too. So I think that's a really good question. And on the excellent question on certification bodies. I think in the US, if the Forest Act is enacted, I think that might be a part of the Trusted Trader program and part of showing reasonable care and, showing the track record of due diligence. I think those could very well fit into the regulatory model here, but granted, we're just a little bit further back behind the EU. But Everett, please, those are my thoughts.
Yeah,
just one point, if I may, Everett, before handing back to you on the certification point, because precisely was now raised by Mila. I think it's also important to note that at the EU level, of course, the certification bodies can help into providing information or sharing knowledge or having outreach with respect to deforestation-free value chains. But at the same time, having a certification from this certification body does not equal to EUDR compliance. So that still means that there still has to be a broader and separate compliance regime, but it's definitely a role that will be adjacent to certain compliance requirements.
Well, we've barely scratched the surface, and it's I really wish we could continue because there's a lot of more issues to unpack. So we may have to revisit this. We have about a minute for closing comments. So let's start where we began with you, Christina, and just a couple of quick points about where this leaves us and what companies should be thinking about, and then we will wrap this one and we will look forward to the next webinar.
Thank you, Everett. I think overall there's still a lot of things to consider this year. At the EU level, we still expect a lot of the secondary legislation to still come up, and therefore a lot of ground to cover coming in the coming months, and that will essentially determine the way that the EUDR will be complied with, and we can provide support both on a policy and also from a legal standpoint.
Wonderful, thank you, Thomas.
I think so. Christina summarized it well. Maybe we should have in mind that the UK is also coming with its own initiative, so it may be a third piece of legislation to take into account in shaping the supply chain quite maybe in the medium term.
Absolutely. Mila?
I would just repeat Everett's statement previously that just because we don't see the Forest Act becoming law in the next 3 weeks doesn't mean that now is the time to interact with lawmakers and with the administration. We didn't even scratch the surface on their inputs and how they're talking about deforestation as well at the State Department, in a discussion led by the State Department. So that would be my last thought for all you all.
Thanks, Mila. Karen?
I would just say it's an exciting time, given that it's an election year in the U.S. And when I alluded to kind of anti-woke agendas crossing the pond to the UK, it was in reference to the UK election as well. So it's very, very interesting time to stay tuned on ESG principles broadly, as they clearly impact a number of issues like deforestation.
Fantastic. Well, I'll just make one final point that was raised on both sides of the Atlantic is that these no law lives in isolation. Thomas pointed out that there are provisions of biodiversity that may become models in the Deforestation Act, and Mila pointed out going forward that deforestation may become an element within AGOA. So there's a lot of interplay, and I think the thing to watch are the principal issues like deforestation, the ones that are really driving policymakers. And they're looking for many, many different tools to effectuate change, and certainly supply chain and trade are one of them. So this story will be continued, and we really appreciate everybody joining us today. Thank you to the magnificent panelists who did a great job summing up a very complicated issue. We're available for any further follow-up questions offline if anybody would like. Please reach out to us. Meanwhile, I thank you for joining us, and I wish you all a very pleasant good morning, good evening, or good afternoon, wherever you may be in the world, and we hope to see you at the next one. Thanks so much.